people want answers. We the people are sick of this shit. We the people are tired of the lies. We the people want answers. We the people are pissed off.
My videos don't necessarily promote one religion. My views and opinions aren't meant to change the minds, opinions, or beliefs of others. Watch with an open mind. Copyright disclaimer under Section 107 of the Copyright Act of 1976. Allowances made for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, education, entertainment, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. All rights and credit go directly to its rightful owners. No copyright infringement is intended. We continue to uncover the profound wisdom within the timeless scriptures. Take care, and God bless.
You're probably wondering right now, what exactly am I trying to say here? What's the main message of this video? Well, I'm arguing for a philosophy of constitutional interpretation called originalism. Now, before you click off, I realize that word sounds boring, but stick with me here. The idea is deceptively simple. Whenever possible, we should try to determine the one true meaning of the Constitution. The one true meaning, however, is not always as straightforward as it might seem. The history of our Constitution is littered with examples of people claiming to speak for the founding generation, while completely overlooking or distorting relevant historical evidence. There are two particular problems that lead to this behavior. The first is what I call the dead hand problem. This is the assumption that the founding generation had a single, unified intent on every matter and that this intent can be discovered through some kind of historical magic. Well, it's wrong. The Constitution is the product of fierce debates, compromises, and deliberate ambiguities. Not everything in the Constitution reflects the intent of every founder. And when discussing controversial topics, it's important to keep in mind the Founding Fathers were just as flawed as we are. In fact, they were arguably more flawed than we are, since they owned slaves, for example, and certainly didn't have the benefit of hindsight. This brings me to the second problem, which I call cherry-picking history. We must always be cautious when someone says that something is obvious. It's quite rare that anything is truly obvious, especially in history. And if you hear someone making a seemingly simple argument, odds are they've cherry-picked history in order to reach their conclusion. If they did include all the messy details, their argument would fall apart. This happens on both sides of the political spectrum. Originalist arguments are frequently guilty of cherry-picking history, leaving out inconvenient facts in order to tell a nice, clean narrative that supports whatever agenda the person has. Now, the inclination might be to dismiss all originalists as backwards, unthinking ideologues, but that's unfair. There are many smart, thoughtful originalists out there and plenty of non-originalists who ignore history just as badly. To name just one prominent example, so before you get too comfortable dismissing originalism, ask yourself, am I cherry-picking history myself? Am I looking at the same evidence as everyone else? Am I ignoring important context? This is the mentality we need whenever we discuss the Constitution. And if we apply this kind of logic to the Constitution, I think we will find that it is a much more interesting and dynamic document than many of us realize. Take, for example, the claim that the Constitution was meant to be a living document. The truth is that the founders never used that phrase, and those who did use it later almost always referring to judicial activism. In other words, judges using the Constitution to legislate from the bench instead of simply ruling on cases and controversies. Justice Potter Stewart complained about it in his dissent in the Land case v. Wade. I think the court has placed itself in a position from which it will be very difficult to escape the charge of having yielded to pressures wholly extraneous to the judicial process. That is, the majority opinion in Roe wasn't based on the text or history of the Constitution, but rather on shifting social attitudes towards abortion. Now, some people think this is a great thing, that the Constitution should change along with society's morals and values. Others think it's a terrible thing that the Constitution shouldn't be tampered with. The reality is that the framers left the question of abortion up to future generations to decide. That was the point of the ambiguity. But again, we have to be careful. Anti-choice advocates sometimes say that the Constitution clearly does not protect a woman's right to an abortion. Pro-choice advocates sometimes say the opposite. Both sides are cherry-picking history. Both sides are guilty of the dead hand fallacy. The Founding Fathers did not have a single unified view on abortion. Abortion was not even mentioned in the Constitution or the laws of the land at the time. In fact, the framers couldn't even agree on what women could and couldn't vote on, let alone whether or not they could get abortions. Some states allowed married women to own property and others didn't. Some states allowed women to vote on certain issues and others didn't. Some states required women to have a husband's permission to work outside the home. Others didn't. You get the point. Instead of telling each other that one side is obviously correct, that the Constitution clearly protects or clearly does not protect a woman's right to an abortion, we should recognize that the founders intentionally left the issue ambiguous. Ambiguity is what allows for different states to experiment with different laws and what allows future generations to re-examine old laws in light of new knowledge, science, and social values. Consider the 14th Amendment, which reads, "No state shall make or enforce any law which shall deny to any person within its jurisdiction the equal protection of the laws." That sounds pretty clear-cut, doesn't it? Well, it took until the mid-1960s for the Supreme Court to use the Equal Protection Clause to strike down racial segregation. Before that, the court routinely upheld racial segregation under the separate but equal doctrine. It wasn't until the landmark case Loving v. Virginia that the court struck down anti-miscegenation laws, prohibiting interracial marriage. Again, the point is that the Constitution is an evolving document that must evolve if it is to remain a force for liberty. If we think the Constitution is nothing more than a static set of commands from the past, we risk turning our country into a museum, a monument to a bygone era. Of course, not every amendment in the Bill of Rights was meant to be applied to every situation. Many of them have limits. For example, the First Amendment does not protect a man who stands in the middle of a highway and yells, "Beware of car," even though he's technically speaking the truth. But a law barring a man from standing in the middle of the street to speak the truth would be clearly unconstitutional. The way I see it, the Constitution is like a ship navigating the seas of history. If we assume the ship has a fixed course and destination, we risk running aground on the rocks of irrelevance. But if we allow the ship to navigate according to the winds and waves of changing times, we increase our chances of reaching safe harbor. So, what should we do with this knowledge? Well, for starters, stop fighting about what the Constitution says and start paying attention to what it does. The Constitution is designed to adapt to new circumstances. The founders knew that the challenges of the 21st century would be vastly different from the challenges of the 18th century. That's why they wrote the Constitution the way they did. It is a bit ironic that so many people think the Constitution is rigid, when its whole purpose is to adapt to new circumstances. Second, we should admit that our system of government is not perfect. No human institution ever is. Our government is prone to abuse, but it is designed to be contained, balanced, and restrained. If we think our leaders are wise and just, that's great, but we must never give them too much power. Even the best leaders can be corrupted by too much power. Finally, we should remember that the Constitution is a human document written by human hands. It reflects the best thinking of its time, but it is not the last word on any topic. The Constitution is not perfect. The framers were not perfect, and neither am I. But I do know that the Constitution is worth defending, that the pursuit of happiness is worth fighting for, and that our experiment in self-government is worth preserving. Thank you for watching this video. To keep videos like this coming, I need your help. Please consider making a tax-deductible donation. Together, we can keep this channel alive and defend our Constitution for years to come.
Thank you all for watching this here video.